The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Welcome to the special edition of the Short Circuit podcast. I'm your guest host, Anya Bidwell, and with me today are two outstanding IJ attorneys, Bob McNamara and Patrick Giacomo. Hi, guys.
Hey, Anya.
Hi, Anya.
Today, we will talk about the legal doctrine called qualified immunity and the cross-ideological effort to convince the Supreme Court to throw it out. The effort seems to be gathering momentum as there are currently 12 fully briefed qualified immunity petitions pending before the U.S. Supreme Court. 10 of them involving lower courts of appeals granting qualified immunity and now petitioners asking the Supreme Court to reverse. Briefly, let's mention the 10 qualified immunity cases in which plaintiffs lost below and are now appealing. Patrick, give me your best two-sentence descriptions for Jessup, Corbett, and Kelsey. All three, by the way, were discussed on the Short Circuit before.
Okay, so Jessup is a case out of the Ninth Circuit where police executing a search warrant stole $225,000 in rare cash and coins. And when the people from whom the coins and cash were stolen sued them, the Ninth Circuit Court of Appeals said that it wasn't clearly established under the Fourth Amendment that police can't steal your stuff.
All right, that's good. Corbett.
Corbett is a case out of the 11th Circuit where a Georgia police officer who was holding a bunch of kids in a yard at gunpoint while they searched for a suspect tried to shoot a non-threatening family dog, but instead shot a 10-year-old in the back of their leg. And the 11th Circuit said that that was not clearly established excessive force by the officer.
All right. Kelsey.
Kelsey involved a situation of horseplay at a pool to which police were called. After the police arrived, as they were talking to people, the person who was actually the ostensible victim of the horseplay tried to walk away from an officer who body slammed the 5-foot-tall woman into the ground, breaking her collarbone. And the appeals court said that there was not clearly established law that that was excessive force either.
Now, Bob, tell me, two sentences each. West, Baxter,
Lightning
and
round.
Zade. Yay!
What are mine? I can go faster than Patrick. I can do this.
Let's do West, Baxter, and Zade.
Okay, West is an IJ case coming out of the Ninth Circuit where Shanice West gave the police her consent to get inside her home, and they took that consent as also including the consent to launch grenades into the home from the sidewalk. Baxter is a case out of the Sixth Circuit where the police unleashed a police dog on a surrendering suspect, and the Sixth Circuit found there was not qualified immunity, in part because a prior case had held that it was unlawful to unleash a dog on a surrendering suspect who was lying down, but this suspect was sitting, so it is in part a case about posture.
That's a big difference.
Posture matters. My mother always said that. And Zade is a case out of the Fifth Circuit where state regulatory authorities went to a doctor's office and rifled through his confidential patient medical records without any kind of warrant or process, which is apparently not okay as one would think.
All right, and then I'll quickly run through the remaining four. Brennan versus Bracey. This guy is on probation. A police officer goes to his house at night to administer a breathalyzer test. The officer turns on the lights and sirens for over an hour, circles the house multiple times, knocking on windows, covers the home's security cameras with police tape. The Sixth Circuit actually says it's a violation of the Fourth Amendment. But the right is not clearly established. Quote, even actions that violate the Constitution do not lead to liability. I'll let it sink in. Actions that violate the Constitution do not lead to liability. Mason versus Fall. A police officer shoots a man 5 times in response to a 911 call, and then after the suspect falls face down, shoots him 2 more times. Fifth Circuit upholds the jury verdict that qualified immunity applies, even though the jury also determined that the use of force by the officer was objectively unreasonable. Cooper. The Fifth Circuit again allows qualified immunity for police officers who tased an unarmed man to death while he was having an acute mental health episode, because the law was not clearly established to provide fair warning to the officers that what they were doing was unconstitutional. Anderson versus City of Minneapolis, a shout out to a friend of the show and the Dean of Berkeley Law School, Irvin Chemerinsky, who is bringing this case to the Supreme Court. The case involves 9/11 responders who prematurely declared a 19-year-old dead despite their own own protocols and deprived him of life-saving medical assistance. The Eighth Circuit allows qualified immunity, finding no violation of clearly established law without even addressing whether there is a constitutional violations. Now, these last two cases are different that I will briefly mention. Lower courts here actually denied qualified immunity to the government officials. Hunter versus Cole, the Fifth Circuit denied immunity to an officer who shot a 17-year-old teenager without a warning, even though the teenager was actually holding a gun. Now, the officer is asking SCOTUS to hold that the shooting did not violate clearly established law. And Davis versus Arnold. Remember Kim Davis? She is the former Kentucky county clerk who refused to issue marriage licenses to same-sex couples. Now the couples are suing Davis for violating their right to marry, and the Sixth Circuit denied immunity to Davis. Davis now asks SCOTUS to reconsider. Bob, given the number of petitions pending, does this mean that the issue of qualified immunity is poised to end up before the justice's next term?
I mean, there are no guarantees, but it certainly seems like there's a critical mass being reached where you can sort of tell all of these outrageous stories of just genuinely shocking qualified immunity opinions. And it seems like the sort of thing where you'd be cherry picking from the last 5 years or 10 years to get this many fact patterns that sound this outrageous. And to have all of them actually just out of this term, all things that have been filed within the past year, I think shows that at minimum, the court has a huge array of options before it if it wants to address qualified immunity. And it's certainly true that the drumbeat of voices from the left, from the right, and from, honestly, the federal bench itself asking the court to reconsider qualified immunity has never been louder. So, the question becomes, if not now, when? And if not one of these cases, what are you really waiting for?
Another thing to quickly note is that a number of these cases also have dissenting judges on the lower courts of appeals that are criticizing the doctrine of qualified immunity itself, which puts the Supreme Court in an interesting position.
Bob mentioned that there's essentially kind of a cross-ideological effort, and folks are pushing for qualified immunity to be reconsidered, right? Patrick, can you talk a little bit more about that cross-ideological effort and what has precipitated it?
So what has precipitated it is definitely more difficult to put your finger on, but there's no doubt that there are people on the right and the left who are fed up with qualified immunity. Both sides acknowledge that the doctrine itself has no legal basis other than the Supreme Court creating it in 1982. And so you'll see anyone from ACLU to IJ to Cato to Americans for Prosperity on the right criticizing qualified immunity. And you'll see the same thing in the legal academy, where you find professors on both sides of the ideological spectrum criticizing qualified immunity. And interestingly, the two Supreme Court justices who have most strenuously criticized the doctrine in Supreme Court opinions are Justice Thomas and Justice Sotomayor. So there's really no easy way to fit this into the sort of political narratives that we're used to seeing when discussing issues that come before the U.S. Supreme Court.
Okay, so then let's dig deeper here a bit. And I think, Bob, your case, IJ's case, West, is kind of like a really good way to demonstrate certain issues with qualified immunity. Could you talk about the case and kind of the issues that the case puts forward before the justices?
Sure. I'm always happy to talk my own book. So West is a case, as I said at the top, where Shanice West came home one day to find her house surrounded by law enforcement officers. There were 5 guys covering every exit, and they were there looking for her ex-boyfriend. And they asked her if he was inside, and she didn't think so. But remember, she's coming home. She doesn't know. She hasn't been in the house. She doesn't think he's there. But they ask for her consent to get inside and apprehend him if he's there. So she nods, she hands him her keys, and she leaves. And instead of getting inside, they summon the SWAT team and engage in a 10-hour standoff, at the height of which they're just bombarding the house from the sidewalk with tear gas grenades. And at the end of 10 hours, they discover that Shanice was right. The house was empty, except for her dog, Blue. And her home was destroyed. She couldn't get inside at all for days. She was homeless for 2 months, and all of her worldly goods were destroyed. And when she sued and said, hey, this was just a warrantless destruction of my house, the defense was, well, we don't need a warrant because we had your consent. Your consent to get inside gave us consent to stand outside and bombard it with grenades. And it illustrates, I think, a couple of pathologies with qualified immunity. Obviously, 2/3 of a Ninth Circuit panel said, no, there's qualified immunity here because this isn't clearly established. There isn't a case on point saying that consent to get into your house isn't the same as consent to launch grenades from the sidewalk. And so without that case on point, the officers are entitled to qualified immunity. And I think we can take a few things from that. One, we should never invite any of these people over to our house for dinner because they will misinterpret the invitation. But two, it shows the difficulty of this clearly established idea. Because the reason there's no case saying that consent to go inside isn't the same as consent to destroy from outside is that, as far as I can tell, nobody's ever even made that argument. Nobody in the history of federal litigation has said, oh, well, I had consent to go inside, and so that means that I got to stand on the sidewalk and launch grenades. And if no one's ever had the audacity to say it, no federal court has ever rejected the argument, and if no federal court has ever rejected the argument, then there's qualified immunity. And so it basically means that government officials have a free pass to violate the Constitution as long as they do it in a sufficiently outrageous and creative way. And that seems like the opposite of the incentive we'd want, right? Like, we don't want people to benefit from more outrageous conduct. That's not how the law works in any other context.
And just to circle back to what precipitated this sort of bipartisan coalition of groups that are against qualified immunity. Like I said, we don't know for sure, but my inclination is that the things Bob has highlighted have kind of caused qualified immunity as a doctrine to reach a tipping point where it just is outside of the norm of any reasonableness. So you've got these situations where there's two things in conjunction. One is the lengths to which they've pushed the distinctions they make for clearly established law. So you'll look at a case like Corbett, and the distinction seems inconsequential for anyone who litigates cases for a living. These don't seem like they're legally distinguishable cases. And the second is a result of Pearson versus Callahan, when the U.S. Supreme Court fairly recently decided that when you do the two-step analysis for qualified immunity, you do not have to first decide whether there is a constitutional violation. And so a lot of these cases now will say, well, regardless of whether there was or wasn't a constitutional violation, it wasn't clearly established either way. And in so doing that, not establish whether there is a constitutional violation that can be used in future cases. And so if you look at a case like Jessup, the Ninth Circuit, in saying that there isn't clearly established law saying police can't steal your stuff, declined to decide whether stealing your stuff actually is a constitutional violation. And so technically speaking, in all of the states covered by the Ninth Circuit, police can steal your stuff and you can't sue them even after this case, because the Ninth Circuit still has not said whether police stealing stuff is a violation of your constitutional rights. And so I think all of this is kind of snowballed into the situation where truly outrageous things are happening and the people who do them are just getting to walk away scot-free. And so you can blow up someone's house with gas grenades, you can shoot a kid while you're trying to shoot a non-threatening dog, you can steal stuff, you can rifle through medical records, and the courts will apply such a surgical standard for determining whether all these qualified immunity thresholds have been met that basically, depending on the panel you can get away with anything now.
It's a huge problem just in the development of doctrine. I mean, the same thing is true in West. The panel didn't decide that it's unconstitutional to take consent to go inside as consent to launch grenades. And so you would still get qualified immunity if you did that today in the Ninth Circuit. But it's also just a deeply bizarre way to develop doctrines. Like, take the warrant requirement itself. Like, the Supreme Court has been very clear that, like, property rights are important, and the warrant requirement is meant to be this ironclad rule that the government can only come onto your property with a warrant based on probable cause. And there are narrow exceptions to that rule. And one of those narrow exceptions is consent. And we're going to jealously guard this narrow exception. And that's everything the court has said about this. But once you add qualified immunity to the mix, what it means is any exception you have to any rule automatically becomes boundless. Up until somebody first violates the boundaries of that narrow exception that you've recognized, the exception doesn't have that boundary. And so anything the court wants to say about the rule is X, but the exception is going to be Y, the exception's automatically going to swallow the rule. And that's just no way to run a railroad. And frankly, it's no way even for government officials. Like, people keep pointing to Jessup as the outrageous case about stealing things. But honestly, one of the groups of people I sympathize with in Jessup is actually the officers. Like, those officers have insisted throughout the case that they didn't steal anything. They didn't do anything. And instead of a court saying, well, let's adjudicate it and let's let you clear your names, the courts have said, well, let's assume you did steal something and we're just going to let you get away with it. Like, I wouldn't want that to happen.
That kind of gets to this issue of the interlocutory appeal as one of the problems with qualified immunity, right? Like, why is it that these officers in Jessup, instead of like being able to prove that they actually didn't steal it, the first thing they do is they invoke this defense of qualified immunity, and now we're essentially fighting in the U.S. Supreme Court over it.
Well, let me first pick a little bit of a fight with Bob, because I understand the point he's making, but I have trouble feeling sorry for the defendants in a case who move to dismiss the case and then complain that the facts have to be considered in the favor of the plaintiff. But the point is entirely. You can respond, Bob.
No, I mean, they did the thing that any sensible lawyer would do defending them. But if I were in their shoes, I'd be mad at a legal system where the way to defend your rights is to have this whole litigation where the baseline assumption is that you stole stuff when your actual court offense is, no, I didn't steal stuff.
Right. Yeah. So I'll highlight for the non-lawyers. The concept of interlocutory appeal means that you appeal the case before it's final in the lower court. So if you file a lawsuit, usually you don't get to appeal the lawsuit until the lower court judge has totally decided to get rid of the case or to allow it to proceed to a jury. And in these cases, the Supreme Court has said when it created qualified immunity, it later said, also, we're going to allow you interlocutory appeal. And the stated purpose of that was so that
several times, right? At the motion to dismiss, at the motion for summary judgment, you get to do it several times.
That's right.
Before you get to the merits.
That's right. And so the ostensible purpose of this was the court saying, well, we really want qualified immunity to get rid of frivolous cases, and this will allow them to be gotten rid of more quickly. And it is abundantly clear looking at all of these cases and basically any other case involving qualified immunity that this interlocutory appeal process draws these cases out a lot longer than they would otherwise have been drawn out. So, for instance, in the Jessup case, if it's true that these officers didn't steal this money and they can show it, this case could have gone to trial within a year, had a final decision by a judge that said, yeah, the cops didn't steal the money. And so obviously we don't have to adjudicate whether there's a constitutional violation, because if they didn't steal the money, there wasn't. And the rest of this stuff becomes superfluous. But instead, because there's an interlocutory appeal process, and just because it takes so long to litigate at each stage, you'll see a 3, 5, 6, 9-year process before you even get back down to the district court if you quote unquote win, which is another interesting piece of this, because a lot of these cases where a circuit court has granted qualified immunity, for the plaintiff to win the case in the appeal doesn't mean they win the case at all. It just means they go back down. And so, for instance, in Jessup, if the case goes up to the U.S. Supreme Court right now, the plaintiff's case has been dismissed by the Ninth Circuit. If the Supreme Court reverses and says something along the lines of qualified immunity doesn't apply, or we're changing qualified immunity and it won't apply, then the case goes back down to the district court in California for fact-finding to decide whether the cops even stole the money in the first place.
So there is this case, Hope versus Pelter, right? That's a U.S. Supreme Court case. And Justice Stevens there specifically says that the test for whether the law is clearly established is whether a reasonable officer would have had a fair warning that what they're doing is unconstitutional. So how do we get from this broad concept of fair warning, right, to this very case-by-case he's sitting down, that other person was laying down, therefore there isn't a fair warning? That seems to not make sense at all, Bob.
I agree. I'll stop there. No, I mean, so Hope, I think, articulates what a lot of people assume the qualified immunity standard means, right? Like when you talk about qualified immunity to lay people, they say, oh, well, it seems fair that you shouldn't hold people liable for breaking a rule they couldn't have known about. Like if you're going to announce a new rule, you can't punish me for breaking it. And like, fair enough. And that's what Hope says. Hope says, look, what we're going to look at is whether it would be obvious to you that you were breaking this rule, not whether there's a case where exactly all the facts were in place and it was exactly 2:32 p.m. and you were using your left hand and not your right hand and you had your shoe untied. But is there a clear rule, and would a reasonable person in your shoes have definitely known he was breaking a clear rule? And I think the difficulty is that the Supreme Court has never said that's wrong. The Supreme Court continues to embrace that as part of the doctrine. But part of what has happened in the past several years is the court has been sending strong signals about what it thinks about qualified immunity without actually changing the law. The court has engaged in a lot of heavy activity in what my friend and friend of the show, I guess I have to say now, Will Bode calls the shadow docket, where instead of taking cases on the merits for argument, the court has been taking a lot of qualified immunity cases where lower courts have found that there was no qualified immunity and just taking them up and immediately saying, no, here there is qualified immunity. This is wrong. And I think lower courts have been taking, not unreasonably, they've been taking the signal that what that means is the court wants you to be really stingy with qualified immunity. It wants you to take this really mechanistic approach, even though the doctrine doesn't actually say you have to take that mechanistic approach. And so taking that signal, you start to see panels saying, okay, the Supreme Court has told me to be a machine here. I'm going to be a machine, and your widget is 1 centimeter too wide to fit into the box I have, because that's the signal I've gotten from the court, is that it's not supposed to be about reasonableness anymore. It's supposed to be about this, like, frankly insane inquiry into whether the guy's shoes were untied in the last case that came up.
Yeah, and I'll just echo that I agree that the public sentiment for this is, well, yeah, it makes sense that you'd give someone fair warning before you'd hold them accountable. Well, the two problems with that in qualified immunity sense are that's not, as Bob said, what the clearly established standard is being interpreted to do now, because the Supreme Court has weighed in so frequently and so aggressively reversed cases where the lower courts didn't grant qualified immunity. But I'll also point out that that's not how the law works for normal people. If you get arrested for something as a citizen of this country, you don't get to say, I didn't have fair warning to know that I violated some federal regulation or whatever it is, regardless of how obscure it is. So on the one hand, the courts will hold knowledge of the law to normal people and allow them to be criminally prosecuted when they violate laws that they don't know exist. But on the other hand, when you have people who are supposed to be enforcing the law, police officers or government officials, they'll say, well, it's not really fair to hold them accountable to the Constitution because they didn't really know, in that there wasn't a specific case on point in the jurisdiction where they were that makes it abundantly clear to anyone that what they did was unconstitutional. And I think that's the huge disconnect in terms of just viewing this thing from a standard of fairness.
There's also just the weird fiction that government officials everywhere are carefully scrutinizing the facts of every federal appellate case so that they can learn these lessons about what they are and are not allowed to do. It's this strange thing where, like, the notion is the only source of wisdom is the federal appellate court in the jurisdiction where you work. And if you're a government official, you can't be expected to sort of take in any information other than those opinions, but you're expected to know every jot and tittle of those opinions, which is just not true on either side. Like, if it's about reasonable warning, we don't actually expect government officials to know whether the guy's shoes were untied in the previous case. And if it's about what people could expect, that the entity that's supposed to teach you not to body slam 5-foot-tall women is not the Federal Court of Appeals. The entity that's supposed to teach you not to body slam 5-foot-tall women is your mom and dad. Like, we just don't have that kind of moral reasoning or that kind of moral intuition in any other area of life or any other area of the law.
Another thing that goes along with that is just sort of the obviousness thing of it, which is what Hope suggested. But in another case by the U.S. Supreme Court called Malley versus Briggs, it said that qualified immunity does not extend to the plainly incompetent or those who knowingly violate the law. But it absolutely does extend to those people, as the crop of cases that are in front of the court this year alone demonstrates. So there's just no way that a reasonable person can look at what happened in the Corbett case where the police officer shot a 10-year-old while he was trying to shoot a non-threatening dog and say that that was a competent officer. And if they do say that it was a competent officer, then the question is, well, did he knowingly violate the law? Why would you try to shoot a dog that's interspersed in a group of children that you have laying on the ground? It just doesn't make sense. And the same thing is true, again, taking the facts as pleaded by the plaintiff in the Jessup case. If it's true that those officers stole $200,000, then they knowingly violated the law. And there's just no reasonable person who would think that that's not the case. And so what you come away from all this with is that regardless of what the U.S. Supreme Court has said, qualified immunity does shield the plainly incompetent. It does shield those who knowingly violate the law. And it goes well beyond any standard of fair warning that we would apply elsewhere in society.
Okay, and that kind of brings me to this idea. Have we always been doing it this way? Can you actually justify it maybe through our historical practices? Or as the friend of the show, Will Bode, says, it actually completely unmoored from the original intent and understanding and practices? Patrick?
Yeah, so the history of official immunity in the United States is basically exactly the opposite of what qualified immunity requires right now. So starting at the founding, going through 1967, there was basically strict liability for any government officer who violated the Constitution. And the courts repeatedly and strenuously said over the years, we don't care why you violated the Constitution. The question for a court is, did what you do violate the law in some way? We decide legality, and we leave to the political branches the policy behind it. And so, for instance, in a famous case in 1804 called Little versus Barrame, there was a ship captain who, on orders of the President of the United States of America, seized a vessel. And it turned out that those orders were not based on a law, and the vessel owner sued the captain and won damages. And the U.S. Supreme Court said, yeah, we don't make excuses. If you violate the law, it doesn't matter whether the president told you to violate the law. And if Congress wants to do something about it, then they can indemnify you for the damages against you, which is exactly what happened.
And it's not necessarily about excuses, right? It's more about focusing on the vindication of individual rights of individuals, and that kind of being concerned very much with that.
That's absolutely right. So it was two things. It was that, and it was the separation of powers. And so the Supreme Court said, we do law, the other branches, they can do policy. And that was how things were from the founding until 1967 in a case called Pearson versus Ray, which is the first time we see the Supreme Court use the phrase qualified immunity, although it's not the qualified immunity we know today. So what happened in that case was the court announced that when it was looking at the actions of government officials that violated the law, that it would carve out a defense of good faith. And so after 1967, for about a decade, the Supreme Court applied this standard, and it would allow officers to say, yes, I might have violated the law or the Constitution, but I did it in good faith, and I was reasonable in thinking that. And usually those cases came about because officers were enforcing an illegal or unconstitutional law or regulation or something like that. And so at that point, it was still a defense that they could raise, and it still meant that those who acted in bad faith or unreasonably, like two categories the court highlights in Malley versus Briggs, would be held liable for what they did. So that was the standard for 200 years, basically, in the U.S., was that the baseline was that government officials were liable for their unconstitutional acts. And then in 1967, they were allowed their first general defense, which was that they acted in good faith and that they acted reasonably. And if they couldn't establish both of those as defenses, meaning it was on them to show the court that they had acted in good faith and that they had acted reasonably, then they were answerable in damages to the person whose rights they had violated.
And I think kind of the thing I take away from the history that sometimes gets lost in the shuffle is that the rule throughout the 19th century wasn't, if you're a government official and you make a mistake, you're exposed to financial ruin. Like the actual, as Patrick points out, the usual rule was indemnification. every jurisdiction would have its own sheriff, and every sheriff would have what's called a surety, an entity that was responsible for paying the sheriff's debts. And there's litigation about when the surety is responsible and when the sheriff is responsible, which is actually where you find a lot of these phrases in the 19th century about good faith and mistake. And so the rule was not, if the sheriff makes a mistake, breaks the door by mistake in the wrong house, that the sheriff is necessarily ruined. The sheriff, if he fails in his duty, has a surety. And what we've done largely by moving away from that system is moving from a system where the question is, okay, a government official made a mistake. Is the government official responsible for paying the damages, or is the surety, it is basically the insurance company, responsible for paying the damages? We've now moved to a system where we say, okay, a government official has made a mistake, and really the person who should be holding the bag is not the government official, not the surety or the insurance company, but just the private citizen. Like the private citizen who happened to be on the receiving end of the mistake, that's the best person to bear all the costs. And that just seems, I cannot imagine anyone sitting down and in the abstract saying like, nope, that's the best system. The best system is for the random victim of government official wrongdoing to be the one who bears all the costs of that wrongdoing.
Right, but that's the system we have now, because in 1982, the Supreme Court, seemingly out of nowhere, created the modern doctrine of qualified immunity. And it looked at the Pearson case that had the good faith defense, and it said, you know what? Looking at an officer's subjective good faith is really messy, and they have to go to trial, and there's fact discovery because we have to figure out what they really thought and what they really believed. So we're just going to not deal with all that. We think it'll get in the way of the government being able to do whatever the government wants to do. And instead, now we're only going to look at objective factors. And on top of that, we're going to flip the burden from the defendant who wants to raise the defense to the plaintiff. And so beginning in 1982, when you're a government official and you violate or arguably violate the Constitution and get sued, you just say qualified immunity. And then it becomes the plaintiff's burden to explain that what happened was objectively a violation of clearly established law. And so it doesn't even matter if you were to admit what you did was done for bad reasons or intentionally bad. That's irrelevant to the court's consideration. And that has kind of seeded everything that's led up to the glut of cases that we see today, where even outrageous and intentionally bad behavior is shielded by qualified immunity.
What caused this shift from kind of like a focus on vindication of individual rights to focus on protecting government officials? Do you guys have any theory for it? Like, why did we end up essentially in this period, 60s to 80s and till this day, where you have a completely different way of looking at constitutional rights?
I mean, it's always hard to come up with grand theories of why the law moved in a certain direction, which is why I litigate instead of professing for a living. But I do think it's telling that in a lot of the Supreme Court cases, going right back to 1982, where the court has really strong statements about qualified immunity and how important qualified immunity is, if you look at the underlying claim, the court's really skeptical of the underlying claim. It doesn't think you've brought a good constitutional claim. It doesn't really think anybody's rights have been violated. And it's in that context that you see the most sweeping statements about how qualified immunity really requires a case on point that provides the officer with warning, that implicitly what's happening in a lot of them is just judicial skepticism of the underlying claim of right, which I think unfortunately gets mixed up a little too much with the statements about qualified immunity. And then those statements about qualified immunity are what act to prevent genuinely meritorious claims from being heard. I mean, I don't think there are many people who would actually go to bat for the idea that when you give the police your consent to go in your house, you give them the consent to destroy it entirely. That's included within the Fourth Amendment. Or that, no, there's absolutely no Fourth Amendment bar to the police just stealing your stuff for personal use. Like, nobody quite thinks that. But because of the sweeping statements we have about qualified immunity, it just stands in between the court and the analysis of the actual right.
Yeah, so I mean, the modern doctrine of qualified immunity is basically a case study in reductio ad absurdum. Like we've reached the level of absurdity now, which is why you're starting to see, I think, this bipartisan support and this sort of group of dissenting judges on the lower courts and comments by dissenting justices on the U.S. Supreme Court. But it's also worth really highlighting that in 1982, when the court came up with the doctrine, it stated at the time explicitly that what it was doing was policy. It wasn't basing its decision on the text of Section 1983, which is a civil rights statute. It wasn't basing its decision on the text of the Constitution. It was just weighing policy considerations and doing what it thought was the best it could do with policy. And in cases immediately following that decision of Harlow versus Fitzgerald, the court itself said, yeah, when we created qualified immunity, it was completely unmoored from the common law. We had no historical basis for what we were doing. And it's just kind of allowed itself to go forward with that doctrine anyhow.
There is this perception among members of the public that qualified immunity is really about protecting members of the law enforcement community, right? Especially in like split-second kind of decisions. The cases that are before the U.S. Supreme Court now, are they all about law enforcement? Do qualified immunity questions generally involve law enforcement? Or does it actually happen in cases involving, completely outside of force type of scenarios, Bob?
I mean, qualified immunity isn't a doctrine about the police. Qualified immunity is a doctrine about the government. It protects any government official who violates constitutional rights in any context. I mean, the Zaidi case is about the state's medical board regulators. It's just an administrative body.
Yeah, let's pause on it for a bit. What are the facts again in Zaidi? Just so people understand.
So in Zaidi, the officials from, I forget what Texas calls its medical board. I will call it the Texas Medical Board, though that is not in fact its name. Is that its name? I don't think it's something.
TM, what they call it in the opinion is TMB.
I got it right. Texas always has longer names for things. So the officials from the Texas Medical Board were conducting an investigation of this doctor and just showed up unannounced and said they were going to start going through his files and didn't have a warrant. And it's the kind of investigation that like any police officer would understand. You need a warrant to do that. But they're not police officers. They probably don't follow the Fifth Circuit's opinions about warrant requirements. And so they just rifled through the files. And I think it's an illustration of how people think about qualified immunity frequently in the use of force context. But it's not a doctrine about the use of force. It's a doctrine about constitutional rights and how seriously, or as it turns out, not so seriously, we're going to take them. And I think concerns about the use of force kind of fall into two camps. One is the concern that individual officers shouldn't be held liable, which is not necessarily a wrong concern, but I think doesn't really match up with the facts on the ground, because just as in the 19th century, where we're talking about sureties who would actually be paying the judgments, studies have shown that judgments in lawsuits against law enforcement are not paid by individual law enforcement officers. They're essentially never paid by individual law enforcement officers. They're paid by insurance companies. And even if that doesn't answer the concern, I think a lot of this just boils down to the fact that the use of force has to be reasonable. And it certainly seems like whether or not your actions were reasonable has to account for the fact that you were making split-second decisions. You were in a difficult situation, and so reasonable gets bigger when you are in a more difficult situation. Would it be reasonable for me to do something if I had 5 hours to think about it? Would it be reasonable for me to do something if I had 5 seconds to think about it? Those are different questions. And I think by layering qualified immunity on top of that, you're essentially double counting. Right? Like not only does it have to be reasonable, we've decided you're unreasonable, even accounting for the split-second decision, but we're going to layer on top of that this extra level of protection. And I think just all of those concerns, when I'm having that debate, I'm having a conversation about reasonableness. And reasonableness is already in the underlying substantive standard in those cases. And I'm not sure what qualified immunity really adds in terms of the outcomes people want to see in those cases.
Right. I think that's a finger right on the pulse, and I think that's dead on. And for whatever reason, that issue seems to get lost in the shuffle a lot. But there's no doubt that reasonableness in the Fourth Amendment context is already baked into the cake. And so they're already looking at an officer's reasonableness as to whether, for instance, he used excessive force or was unreasonable in arresting someone. And so then to add a different gloss on top of that makes it basically makes a plaintiff show double unreasonableness is a huge problem with qualified immunity. And in the more boring context of procedure, we see that a similar double counting with this interlocutory appeal procedure, because the basis that the court uses to explain why it's necessary, which is to get rid of frivolous cases, is already covered by any number of other federal rules or judicial doctrines that allow courts to toss out frivolous cases or make plaintiffs provide more evidence to support their cases. And so you kind of have this layering effect going on in multiple ways where qualified immunity is put over the top of doctrines that already allow the things that the court says the policy of qualified immunity is aimed at to be addressed.
And qualified immunity, of course, is not the only obstacle to government officials' accountability, right? They get a number of additional protections, too. So, for example, Patrick, in IJ's case that you're spearheading, King versus Brownback, now Brownback versus King, you actually prevailed on the question of qualified immunity, right? And yet, from what I understand, you're still not able to get the government officials who assaulted James King to answer the complaint.
Yeah, that's right. So just for those of you who haven't heard about the case, James King was an innocent college student walking down the street in Grand Rapids, Michigan, when he was approached by two men in plain clothes who were driving a black SUV, who began talking to him, then quickly threw him up against their car and removed his wallet, at which point he believed he was being mugged and tried to run away. It turned out that what James didn't know was that one of these guys was an FBI agent, the other was a local police detective, and they were working as part of a fugitive task force. And when James tried to run away, one of the men tackled him and choked him unconscious and ended up beating him very severely in the face. And James was actually prosecuted for resisting arrest, even though he wasn't the fugitive and had done nothing wrong, and ultimately acquitted by a jury on all charges. And so when that was done, James, we filed a civil rights lawsuit. And like we were just talking about, the first threshold issue is what these officers did unreasonable under the Fourth Amendment? And so you already have the first layer of reasonableness built in there. We filed the case, and they moved to dismiss the case for several reasons, but primarily on the basis of qualified immunity, which the district court granted and said it's not clearly established that what happened here when these plainclothes officers choked James unconscious and beat him severely in the head and face, despite the fact that he was not the guy they were looking for. It's not clear that that was excessive force or an unreasonable search or seizure. So I'm going to grant qualified immunity. Well, we took that case up to the Sixth Circuit, which reversed and said there is no qualified immunity here. This case should go forward.
So yay, we overcame that major obstacle, right?
Yeah, yay. It only took 3 or 4 years. James has only been dealing with this for the better part of his entire adult life. And we're ready to go forward and see if, as we talked about at the beginning of the show, if the officers can plead their side of the case and maybe what they did was reasonable. Who knows? We don't have any factual findings yet. But the case is not proceeding in the district court because instead of going back down, the U.S. Solicitor General petitioned the U.S. Supreme Court to, after losing unqualified immunity, create yet another special protection that would shield federal officers from liability under the law. And so basically what we have is the Constitution itself builds in certain reasonableness requirements that were applied, and then we have qualified immunity laid on top of that. And when the circuit court said qualified immunity didn't apply, now the government's petitioning the U.S. Supreme Court to create another type of protection. And the Supreme Court's going to hear the case next term. And so the point is just there are already protections built into the system. Qualified immunity is there, adding more, and now the government seeks even more protection than that. And it's just kind of, that's the way, the ratchet that things are going to be working in forever, it seems.
And King is a part of IJ's project on immunity and accountability. And Bob, West is part of that project too. Can you briefly, before we go, tell our audience about the project and what it's trying to accomplish, and whether it only deals with qualified immunity or goes beyond it?
Sure. The Project on Immunity and Accountability is based on the simple premise that we believe the Constitution is a promise. It's a promise of individual rights, and we think that promise is meant to be kept. And there are all of these doctrines out there, including but not limited to qualified immunity, that make it difficult to impossible for individuals to actually vindicate their rights. And we think the Constitution is important. We think it protects important rights, your right to property, your right to pursue an honest living, your right to speak freely. And if those rights cannot be enforced, then the Constitution is a meaningless piece of paper. We think it's a lot more than that. And the point of the project is to make that a reality.
On that note, Bob and Patrick, thank you so much for being here. We will continue this conversation and we'll keep an eye on those petitions.